yeah, we're here today for the session on managing whistleblowing compliance and risks in life sciences. My name is Paul Gershlick. I'm a partner and head of Pharma and Life Sciences at the law firm VWV. We've been members of EMIG for over 10 years now, and I co-chair the Compliance Special Interest Group with Paul Ranson, who I'm going to bring in a few moments. This session is being provided in conjunction with EMIG and VWV. It is actually an EMIG compliance and HR special interest group meeting combined. EMIG is a members organization for a lot of pharma companies and other people involved in pharma, and really makes the case for pharma in various ways. There are some very interesting special interest groups, and this particular topic is really a confluence between compliance and HR. I know that there are also some people who have joined today coming through the VWV Pharma and Life Sciences mailing list. So whoever you are and wherever you've come from today, you are very welcome. So I'd now like to bring in my colleague Paul Ranson, my co-chair of the Compliance Special Interest Group. Paul, we've been running these compliance sessions for some time. Today's session actually has come as a result of the suggestion of one of our attendees today, one of the delegates who made some suggestions a few weeks ago, and top of the list was whistleblowing. Paul, what are your thoughts for what you're looking for today?
Those of us with long memories will remember, and I noticed there's a number of people from Roche on the call today, the Stanley Adams case a long way back, even before my time, and it was very much a cause célèbre in the pharmaceutical industry. It was around price fixing. Obviously, this will be way before the time of anybody on this call. But I think it's always been a sensitive area within the industry, and I think rightly so, because not only around the pricing, the competition area, but it's also a major factor. I mean, I've come across cases recently, or handled cases recently, around, for instance, concerns or allegations around good manufacturing practice and manufacturers' license breaches, but also one sees that around the breach of the advertising laws and the code. And I was interested to find on Bob's views as to the extent to which for instance, the whistleblowing laws apply to the code in terms of it's not legally enforceable. So those are the areas I'm particularly interested in. I think the code area and the manufacturers' licenses and other GXP issues are obviously front and central in how the industry may have to deal with a whistleblowing case. So I'm particularly interested in what Bob has to say, and very grateful that we can dovetail with Jim's group, who's going to come next, because clearly, as Paul elegantly said, it is at the confluence of compliance and HR issues.
Thank you very much, Paul. And Jim, yes, as we say, this is the first joint EMIG compliance and HR special interest group meeting. So Jim, what are your thoughts today? And I know when we've built up today, I know you think this can be a bit of a minefield.
Yes, welcome everybody. My name is Jim Golby. I'm the chair of EMIG's HR group. Paul, thank you for suggesting that I wasn't around when the Roche cause célèbre case happened, but sadly I was, as I joined the Pharma.
Only the tail end, Paul. Jim.
I joined Pharma in 1982, so I remember it well. So first, I'd just like to welcome all the EMIG HR group members along today. I'd also like to thank the folks from VWV for presenting to us today. It's also, as Paul's already highlighted, this is yet another tricky topic for HR departments, and I'm very much looking forward to what Bob has to say today. And I have a few questions for him at the end, but I'll try and keep them easy, Bob. So looking forward to your presentation.
Thank you very much, Jim. And Paul, thank you to you both. We are bang on time. Thank you. And what we really want to do is hear from Bob to tell us all about managing whistleblowing compliance and risks in life sciences. Just a reminder before we get going that if you've got any questions, please do provide them in the Q&A section at the bottom, and we will cover the questions at the end. Bob, over to you.
Thanks, Paul. Good morning, everyone. I think that's the biggest build-up I've had to presenting a webinar ever, and yeah, no pressure at all. I'm Bob Fahy. I'm a partner in the employment team at VWV, and as the others have said, I'm going to be taking you on a whistle-stop tour through whistleblower protection. And then with my imposter syndrome in full blast, I'll touch a little bit on the regulated environment, which, as you can probably imagine, for an employment lawyer talking to a group of compliance specialists is a terrifying prospect. So you'll probably find that that's a relatively short part of the presentation compared to actually talking about the whistleblower protection regime. And then I'll finish by thinking about some ways of making and preparing effective whistleblowing policies to help you manage your risks. Some of the strategies that you might want to adopt in pulling together the points we cover about the whistleblowing regime and how it interacts with the heavily regulated world of pharma. So what is protected disclosure? Well, it's actually the legislation governing whistleblowing is a rare example in the UK of a successful private members bill. The Public Interest Disclosure Act became law in 1998, actually changed the Employment Rights Act with some amendments to introduce for the first time ever in the UK protection for whistleblowers. The reason for the introduction of the legislation was the series of reports regarding various disasters and financial collapses over the course of the 80s and 90s. You may remember reports on the Zeebrugge disaster, Barings, BCCI, various instances like that, which gave rise to a concern that there were in some organizations, in many organizations, in fact, there were cultures within those organizations of regarding raising information about wrongdoing in the organization as something to be actively discouraged and punishing people for doing so. And that was reported to be a root cause of a lot of the problems and serious failings that had happened, this culture of secrecy and lack of transparency. And so the protected disclosure regime was brought in the late 90s. And on the slide, I've set out a definition of protected disclosure. What I've actually done is to consolidate two different parts of the whistleblowing regime. What the Act actually does is creates a definition of something called a qualifying disclosure. And then it identifies the people to whom a worker can make a qualifying disclosure in order for it to become a protected disclosure. It's dense enough as it is, so I've tried to make it a little more simple for you. So a protected disclosure is any disclosure of information to one of these defined categories of people, which in the reasonable belief of the worker making the disclosure is made in the public domain and tends to show that one of the specified types of wrongdoing or failure has happened, or is happening, or is likely to happen. And I've highlighted the various parts there of the disclosure that we're going to dive into in a little bit more detail. So first, we'll look at the defined categories of wrongdoing. If we can move to the next slide, please, Tamar. And you can see it's quite a broad list. So criminal offences, miscarriages of justice, dangers to health and safety, damage to the environment, the deliberate concealment of information about any of those things. And I've deliberately left this one to last, even though it's not in the right order. But the one that most often we actually see in practice is the second one down, a failure to comply with any legal obligation. And hopefully that's pretty obvious that it's that's an incredibly broad category for workers to rely on as being information that they're disclosing. Paul mentioned that Paul Ranson mentioned in his part of the introduction that he was interested in hearing whether breaches of the ABPI code in particular would fall within the whistleblowing regime. And my view is that it normally would not, because of course the code is voluntary. The only sanctions for it are the public shaming by the ABPI and in respect of membership. So it's not a legal obligation in my view, and therefore breaches of the code would fall outside of the regime. So let's move on to the other parts of the definition. This is the bit that once you've got a qualifying disclosure, you work out whether it's protected or not. You have to identify who workers can actually disclose to. And the most straightforward disclosure is a disclosure to the employer. And as far as your organizations are concerned, most of the time that is where you're going to want workers bringing their concerns rather than any of the external third parties. Now, the definition of employer is quite broad and might include disclosures simply to line managers or to the HR department. And this is one of those areas where having a clear whistleblowing policy that identifies the person or persons to whom employees should be taking whistleblowing type concerns can be of real help in managing risks of things going wrong in the whistleblowing regime. One point to mention, I've mentioned wider disclosure to authorized third parties on the list. What I mean there is if you have a whistleblowing procedure that authorizes disclosure to a third party, so quite commonly that might be an external hotline, you might actually opt into allowing external disclosures to regulators in your policy. But if you do that, then nominating disclosure to that third party means that a disclosure to them is treated the same way as a disclosure to the employer. So important if you're going to do that to make sure that there are clear lines of communication to the external third party. As I say, disclosures outside of the employer tend to be more complicated and often have additional hoops for workers to jump through before their disclosure is protected. I'm not going to run through every bullet point on the list. One, because I'm conscious of time, two, because I don't want anyone falling asleep on me. But a couple of examples. So, for instance, disclosure to what's called a responsible person will be a protected disclosure only where the worker reasonably believes that the malpractice they're complaining about relates solely or mainly to either the conduct of that person in particular or to a matter which is that person's legal responsibility. Rather than the legal responsibility of the employer. And in my view, that's actually going to be quite a rare find in the pharma industry. The most common example you see of that would be professionals like ourselves, solicitors or accountants, who see some kind of malpractice at a client, and rather than making the disclosure to the firm that employs them, makes the disclosure to the client. That might be a realistic example of a responsible person under the Act. Another example would be the prescribed persons. Now, this is a statutory list of regulatory, in the broadest sense, organizations, which is created by statutory instrument, and it currently includes, for instance, HMRC, Ofcom, the Health and Safety Executive, the Information Commissioner's Office. So that kind of style of organization, if you like. It also includes various NHS regulatory bodies. It includes the Secretary of State for Health and Social Care. It includes the General Pharmaceutical Council. It doesn't, as far as I can see, checking over the list this morning, include the MHRA, which I was actually a little surprised to see. But in terms of these extra hoops to jump through, a disclosure to a prescribed person is only protected not only if it meets all the other elements of the definition, but also if the worker reasonably believes that, firstly, the default falls within the remit of the prescribed person, so it's kind of apt for that regulator, but also that the information disclosed and any allegation contained in the disclosure is substantially true. And that's a much higher test than the level of reasonable belief in wrongdoing that's required for a disclosure within an employer's organization. I've listed 3 of the key elements on the slide. What is a disclosure, and then talked about the reasonable belief of the employee, both in the wrongdoing and the public interest. So disclosure isn't defined in the legislation anywhere, but it's very clear from its application in employment tribunals that the term is widely applied. So a disclosure of information applies whether it's made in writing, whether it's made verbally. Most of the time you'll see it in letter or email form nowadays, but that's not required. Simply raising something verbally can amount to a disclosure of information. In terms of the employee's reasonable beliefs, there's both the public interest and the belief in wrongdoing test do skew in favor of allowing as wide a remit of protected disclosure as possible. That's for the policy reason of wanting employees to have a substantial degree of protection when raising issues of malpractice. So a worker does not have to prove that the facts or allegations that they raise or make are true. They don't have to prove that a wrongdoing they allege, for instance, breach of a legal obligation, it amounts in law to an actual breach of a legal obligation. As long as the worker subjectively believes that the relevant failure has occurred or is occurring or is likely to occur, and that belief in ultimately the view of the employment tribunal assessing their claim is objectively a reasonable one. It doesn't matter if the belief then subsequently turns out to be wrong, or that the facts alleged wouldn't amount to a breach of a legal obligation in law. As long as they subjectively held the belief and the tribunal objectively assesses it to be reasonable, then it clears that hurdle of the test. And then in terms of the public interest element of a protected disclosure, that was a change to the legislation that was introduced to correct what the legislators regarded as the wrong interpretation by the Court of Appeal in a case involving Sodexo, Parkins and Sodexo, where essentially the employee in question raised a grievance that was personal to them alone, essentially, and that complaint was found to amount to a complaint that was about a legal obligation and within the scope of whistleblowing. And legislators thought that that's not what the purpose of the whistleblowing regime is meant to address, and so they brought in this public interest test. But all that is required to establish a public interest, or to overcome the public interest hurdle, let's say, is for a tribunal to determine that a worker subjectively believed at the time the disclosure was in the public interest, and if so, that it determines that that belief was objectively reasonable again. So mirroring the previous balance between subjective and objective elements of the test. I've mentioned the case of Chesterton Global and Nur Mohammed. That involved disclosures by a manager at Chesterton's estate agents about manipulation of the company accounts. And the reason that was brought was because the employee in question suffered in loss of commission as a result, and also believed that it had an adverse effect on the commission income for about 100 other senior managers, and so tried to say that's a sufficiently big class of people to fall within the public interest test. And so the tribunal's given guidance on it. The EAT gave guidance on the approach that tribunals should take, and that they include reminding tribunals that there might be more than one reasonable view as to whether a particular disclosure was in the public interest, and so the tribunal shouldn't substitute its own view. And the phrase in the statute is "in the belief," which is not the same as "motivated by the belief." So belief in the public interest needs not be the predominant motive for making the disclosure. So if the employee is largely motivated by a personal grievance, it is still possible for them to reasonably believe that there is a wider public interest that is engaged. And there's no absolute rules about what the reasonable view to take is. So employment tribunals have to apply a matter of what the court said should be a matter of educated impression. So again, there is the public interest hurdle to overcome, but the threshold is a matter of assessing what was actually believed at the time and assessing whether that was part of what was in the employee's mind and whether it was reasonable for it to be in the employee's mind when they made the decision. So those are really the key elements of protected disclosure. In the next couple of slides, I'm just going to look at the actual protections that apply for people who've made a protected disclosure. I'm going to have a look at detriment. So employees who suffer a detriment as the result of having made a protected disclosure can bring claims in the employment tribunal seeking declarations that this has happened and compensation based on the injury to feelings they've suffered as a result of that detriment. So again, detriment's not defined in the Act. As it says there, largely it means anything that a reasonable worker would regard as a disadvantage in their workplace. If it passes that test, it can amount to a detriment. It includes both acts and deliberate failures to act. And the scope of liability for whistleblowing detriment is quite wide. So first of all, employers are vicariously liable for detriments by the individual's co-workers unless they can satisfy the statutory test of having taken all reasonable steps to prevent the detrimental treatment. And as an absolute baseline for satisfying that defense, you will need to have in place clear whistleblowing policies. You will have to have trained your employees in respect of those whistleblowing policies, and you will have to regularly update the policy and the training. That's your starting point. If you can't establish that, then there's no chance of establishing the defense. And it may be that in specific circumstances, more is required as well. So it's quite a high threshold. The other important point is that individual workers can also be personally liable for the acts of detriment that they subject their co-workers to. Now that might be line manager to their reportee, that might be board level to anyone in the company, that might be someone in the HR team to the worker involved. So the scope for a claim is relatively wide, which is just to emphasize the importance of getting it right, rather than trying to scare you all to death about whistleblowing claims. As we move on to the next slide, please. So this is the other side of the coin. Detriment happens in the workplace and relates to action short of dismissal. The other remedy for protected disclosure is where an employee is dismissed because they've made a protected disclosure. And if that happens, then the dismissal is automatically unfair. And automatically unfair means, unlike in what we might call a normal unfair dismissal claim, where the tribunal would be focusing on whether the employer had a fair reason for dismissal, whether they conducted a fair investigation and gave the employee a reasonable opportunity to respond, and whether the decision that they came to after going through a fair process was in the range of reasonable decisions open to them. There's none of that. If you establish that the reason for dismissal was the protected disclosure, then it's unfair as of right, and there's no need to look at fairness of the process or reasonableness of the decision. The other very important points about an automatically unfair dismissal for whistleblowing is that it's a day one right. So there's no qualifying length of service, unlike a normal unfair dismissal claim, which requires 2 years continuous service. If you're dismissed for whistleblowing on the second day of your employment, for instance, then you can bring an automatic unfair dismissal claim. And there's no upper cap on the value of the compensatory award. So the current cap on compensatory awards for normal unfair dismissal claims is somewhere around, I think, £94,000. Don't quote me, I haven't looked it up for a bit. But there's no upper cap. So if an employee is dismissed for whistleblowing and they're very highly paid, and or they're out of work for a very long time, the tribunal says that they've made reasonable efforts to mitigate their loss, they can recover whatever loss of earnings they've suffered as a result of the dismissal. And I'll come back to why that I think is significant when we talk about the regulatory regime. In the next few slides, I'm going to look at the pharma sector's regulated environment, not in any great detail, but just hopefully to prompt some thought about some of the key areas where whistleblowing may be more likely to arise. And I've been thinking about this, and I think it's possible to broadly categorize whistleblowers into three groups. So firstly, you've got those for whom the act was actually designed. So the employees or workers who encounter some kind of wrongdoing in the workplace and need to bring it to their employer's attention because they feel that it's a matter that needs to be addressed. Secondly, and this group is probably the one that that I interact with the most, is workers who have some kind of personal dispute with their employer. And in the course of that dispute, they make a complaint or raise an issue that, as the relationship deteriorates, they, with the benefit of hindsight, later seek to rely on as being a protected disclosure. Now, sometimes they're right. Sometimes the way in which the complaint or issue has been raised is one that ticks the various boxes, but not always. And sometimes the attempt to rely on the whistleblowing protection is perhaps on the cynical side, and it might be from someone who has lost their job when they've got less than 2 years service and is unhappy about that, and is wishing to find a way to pursue claims against their employer and get around the restriction of needing 2 years continuous service. So that's quite a, if I can put it this way, quite a broad church, but gathered around the kind of theme that they're really motivated by a falling out between themselves and their employer in some way. And as I say, that's a group that I see a lot in the employment tribunal claims work that I do on behalf of respondent companies. And finally, and I think that this is quite an interesting group for the pharma sector, there are those whose role within an organization necessarily involves reporting on risk, and where their reporting on risk interacts with a regulatory regime that has the force of law, then those reports won't always, but may satisfy the definition of a protected disclosure. So with that in mind, if we just move on to the next slide on the regulated environment, please. So I'm going to run through these slides, as I say, quite quickly. Oh, sorry, I think we've gone one further. Yeah. So just again to frame these thoughts in your head. So as I'm sure you're all aware, in the pharma sector, there's a number of regulatory regimes and bodies. There's the regulation of clinical trials. There's GMP or GXP, as Paul said, so not just GMP, but GDP as well. Safety features on medicines and the legislation derived from the Falsified Medicines Directive, the world of marketing authorizations, and you've got the MHRA as a legal regulator and the ABPI as a voluntary sector regulator. And all of those things will have various degrees of interaction with the whistleblowing regime, some not much at all, and others quite substantially. Moving on to the next slide. Thank you, you got a sneak peek of this. So I've just pulled out the GMP principles and listed them here, really as an illustration more than anything else of the nature of interaction that might happen between the regulated regimes. So what you've got here are the various different obligations that are required as principles of GMP. You know, the quality assurance system, sufficient number of competent and appropriately qualified personnel, the premises and equipment regime, documentation practice, clear defined procedures. For those of you involved in this world, you'll know this far better than I do. But the important point from the whistleblowing perspective is that it's baked into GMP that you have to have effective quality control systems and you have to have a regime of repeated self-inspections. So there are people in your organizations responsible for GMP compliance whose role it is to raise issues of quality control failures or concerns. And those failures or concerns being raised will not necessarily always be protected disclosures, but there may well be circumstances when they would qualify. And so the way in which they're addressed becomes doubly important. If we move on to the next slide, then just finally to say about the regulated environment. I've mentioned transfers of value to physicians because Paul Ranson asked me to, and so I might well ask Paul to talk to you about that, either if you want to now, Paul, or in the Q&A. But
Yeah,
just we'll go ahead, Paul, if you just want to.
Okay, fine. I mean, if apropos of your first answer to my question about legal enforceability, it's an interesting one because, as I'm sure everybody in this call knows, the transfers of value to physicians, what the US calls, a lot of people call sunshine laws, that is not actually a legal requirement as yet. It is in some countries in Europe, such as France, but not the UK. So at the moment, that is simply something that is a requirement under the ABPI code, as far as I'm aware, unless I'm out of date. But so, as far as I'm concerned, that doesn't seem to fall within the whistleblowing regime. If somebody has a different view, but as far as I can see, it doesn't, because, as I say, the way that the transfers of value came was from EFPIA, then that was taken over by the EPI, and at present it has no legal force other than outside the trade within the trade associations. I mean, clearly, if we're talking about moving on to bribery laws or whatever, then that's quite different. But as far as that's concerned, I would be interested in anybody's contrary view.
Great, thanks, Paul. And then the other 2 points on that slide, I've mentioned qualified persons and responsible persons, just because going back to the point I was making in the last slide, I think that those are probably two fairly obvious examples where someone's actual integral role may well involve them in disclosures that might fall within the scope of the whistleblowing regime. And that, that needn't be a concern to your organizations as such. The fact that the regime's engaged is not in itself necessarily something that causes you risk. Where things go wrong is where there's some kind of potential to allege detrimental treatment or even dismissal of someone who's involved in that regime, and they seek to link it back to having raised those disclosures in the course of their job. So how do you manage that risk, really? And as I say, if we move on to the next slide now, Tim, my kind of key point as your starting place is having an effective whistleblowing policy. So what do I mean by effective? So the main objectives of a whistleblowing policy are really about creating and engaging a culture where making a protected disclosure is encouraged, and that the way that the information raised in those disclosures is dealt with is done transparently and clearly and is well communicated, so that your employees have no concern about raising issues to you, and in fact are actively encouraged to do so, so that you can deal with them and put right. Because of course, in the world that you operate, you will want to make sure that you're not having any risk of breaching legal obligations or creating health and safety concerns. So it's, there's no good reason for an employer not to want its employees to be raising these issues with it. And I've listed on the slide what I would say the main objectives are. So highlighting the seriousness and importance of identifying, remedying wrongdoing, of course, encouraging workers to raise these concerns internally promptly rather than going to one of those external bodies that might fall within the scope of the regime. Setting out the required standards of behavior, identifying who to approach with a concern outside the line management structure if necessary, so that you have clear channels of communication, and so you minimize the risk of something simply being said to a line manager that's later relied on in support of a client. And also to allow you to address the underlying issue, of course. I tend to look at it through the filter of the employment lawyer who's defending you in the employment tribunal, but of course, you want to actually deal with the underlying issues too. Outline the procedure for investigating disclosures and remedying wrongdoing, so people know what you're going to do when they bring the issues to you. Outline the sanctions. I've used the word victimizing. I use that in its very generic sense here. So treating whistleblowers badly, subjecting them to a detriment, is something that you don't want any of your employees or workers to be doing, and you need to have a clear regime for disciplining people who do that. And also outlining sanctions for making malicious allegations. Because while you do want disclosures that are genuinely and reasonably made, you don't want people using the whistleblowing regime as a vehicle to attack in an unmeritorious way. So those are the main objectives. So what do you do to create the whistleblowing policy? What's the process you go through? Well, obviously I will say you can talk to us about the actual draft and wording, and one of the things I would very much encourage is keep the language as simple and clear as possible. Try not to go into too complex an explanation of legal regimes or such like. So in terms of strategy, 4 very simple points really. Identify the areas of greatest risk. Perhaps some of the points that I've made about the areas of compliance within your organizations might help you to do that. Draw on your organization's past experiences. So have you had whistleblowing issues before? Have you had issues with compliance with any of your regulatory regimes or legal obligations that might inform areas that you need to target? Identify key senior stakeholders, and that's really important. This has to, for an effective whistleblowing policy to work, it has to be senior leadership team led. It has to have genuine organizational buy-in, and people need to trust that the organization will deal with things in accordance with what you've got in your policy. And then finally, perhaps consider methods of measuring success. So maybe do you want to conduct, say, annual reviews, seek employee feedback on the policy itself, monitor disclosures that are made to the person identified and how they're addressed, and consider whether anything within that review creates lessons to be learned, either in terms of the policy itself or how it's implemented. So I think that's everything for me, and I think, like Paul, I'm pretty much on time. I may have run over slightly, sorry about that. So if anyone has any questions, I hope to be supported on the regulatory side by my colleagues Paul and Paul, but on whistleblowing matters in particular, or anything else, fire away.
Thank you, Bob. And we have had some questions in. We've got, there was one that was actually put in the chat. If I could ask if everyone can just put your questions in the Q&A. Just to start with one question, Bob, which I think the question was probably put in before you then moved on to answer it, but maybe you can clarify this. Does good distribution practice not come under the regulated environment? I think there's an easy one to that.
Yeah, and I think the short answer is yes. So that's
because it's a GXP, and you said it extends. Yeah, I
don't know a lot about GDP, to be honest with you, but I understand that, like GMP, it's regulated by the MHRA under a legal regime. So unless I'm wrong in that, it would come under the regulated environment. Yes. Okay,
thank you. And another one: are there any plans to change the current whistleblowing regime?
That's an interesting one. So the BEIS in, I think it was 2021, conducted a review of the whistleblowing regime and did, just trying to remind myself, I think it did say that it was planning to introduce, a single body to enforce workers' rights, including whistleblower protection, as part of the employment bill. Now that's been lurking around in a back drawer of the various government policy reviews for quite some time. So there is a proposal to review whistleblowing protection, and the government has said that there is a wider interest in reforming whistleblowing law, and it's going to conduct another review in due course. That's about as far as we go with plans to change the regime. There were a couple of private members' bill. I think there has been a private members' bill in the Lords within the last 12 months. Like most private members' bill, BEDA itself being an honourable exception, they don't tend to go very far. So I think watch this space. There seems to be an acknowledgement that there is scope for reform of the regime. I don't think it's going to be high on the list of any particular government's agenda in the near future.
Thank you, Bob. But like all these things, watch this space, because there's a review out there and who knows which way it might go.
That's right.
Okay, just a reminder to everyone, I did just say it a few minutes ago, we're still getting questions coming into the chat. I am just looking at the Q&A section. So please, if you've asked something in the chat, please can you put it in the Q&A section. So here's another one, Bob. I'm a QA auditor. I inspect our suppliers. We probably have an NDA with those suppliers. So if I spotted something damning, I would try and sort it out with them. However, if they didn't want to cooperate, could I still whistleblow with an NDA in place?
Yeah, that's a really great question. The short answer is yes. So the Protected Interest Disclosure Act contains provisions that specifically say that confidentiality obligations are void insofar as they purport to prevent someone making a protected disclosure. So yeah, thank you for the question. That's a really good one. And I'd make the wider point that that applies within the workplace as well. So if you have confidentiality obligations, as most of you, if not all of you will, in your employment contracts, you probably see a clause in them that says nothing in this clause affects your right to make protected disclosures under the section whatever of the Employment Rights Act. And that's specifically to show that the confidentiality obligation doesn't seek to introduce the requirements of public interest disclosures. And if you don't have, you probably should have a clause to that effect in your confidentiality clause in employment contracts. So you know the same principle will apply to a commercial NDA with a supplier. You can't contract out of a whistleblower's right to make a protected disclosure.
Thank you, Bob.
But sorry, just another point. But because that you wouldn't be blowing, well, you may or may not be blowing the whistle within your employer. But bear in mind the fact that if you wish, if your disclosure was going to be protected, and you're making a disclosure outside of your employer, there might be some of those what other hoops to jump through before you get the benefit of the protection.
Thank you, Bob. How would it be established if the reason for the dismissal was a protected disclosure?
Well, in practice, it's a matter of both sides presenting witness evidence to a tribunal as to why the employer did what they did. Usually there's quite an ex-employee who's bringing an automatic unfair dismissal claim, tries to undermine the basis that the employer relies on for dismissal, and asks the tribunal to draw inferences from any kind of evidence that they can put forward that might suggest a causal link. So it's the same kind of fact-finding exercise that a tribunal will undertake in many claims. You know, first the employee says, "Here's what I said," and they say they dismissed me because I wasn't up to my job or I did something wrong, or you know, whatever it might be. But actually, the real reason is this. And then, if you can't get a deal done on settlement, off you go to an employment tribunal to try and persuade a judicial panel which of you is right and which of you is wrong.
Thank you, Bob. Bob, we've got some more questions still yet to be answered. Just before I ask those, Jim and Paul, bearing in mind we do want to get through the questions if we can. Do you have any thoughts so far, or shall I keep going with the questions? Jim first. Jim, you're on mute. If you had any.
Somebody already asked my question, which was, is there going to be any change to the regime? One question I might throw in here, and sorry to drop this on you.
I wouldn't feel like it was a proper EMIG webinar if you didn't, Jim. So fire away. Well,
here we go. So in a disciplinary policy procedure perspective, the guidance was have a great policy, but then follow it. Don't deviate from it, otherwise that could get you in a tricky situation. Now, yes. So therefore, does the same apply? And the comment was, if you're not going to follow your policy, don't have a policy. So in the same extent here, where most folks have got a policy, clearly they should follow it, are presumably the consequences of not following an existing policy that they had would be similarly, if that's the word, problematic.
Yeah, two things about that. One, I would say I'd qualify your proposition a little bit by saying, if you're going to have a policy, follow it, or say when you're not going to follow it. So, say,
but wouldn't
we
you
have a disciplinary procedure, but we reserve the right not to follow it in these situations, for instance.
But you'd have to have that in the policy, wouldn't you?
Yeah,
Yes,
that's exactly that's the point.
Yeah.
And then broadly, in response to your question, yes, that's exactly going back to how do you show that someone was dismissed because they blew the whistle. The fact that you've got a whistleblowing policy and then ignored it might be something that an employee does well try to rely on as evidence from which the tribunal should come to the conclusion that that was the reason for their dismissal. So there are certainly risks that arise from having a policy in the drawer, never looking at it and not following it.
The reason I ask that is because not in a whistleblowing scenario, but in a disciplinary procedure scenario, we went to an IT on the basis that we hadn't followed the policy because we wanted to be more than fair to the individual concerned. And that was what was thrown at us. And what we done was we believe definitely the right thing, and the right thing to be fairer in the circumstances of the individual. And that's what was thrown at us. But the tribunal agreed that what we'd done, although it wasn't stated in the policy, was absolutely the sensible thing to do, if that makes sense.
Yeah.
And we treated the employee better than the policy would have actually suggested we would treat them.
Okay, Jim, thank you very much. Just with an eye on time, that's been very interesting. And Paul, did you have anything?
Just very brief, more of an observation than a question. You talked, Bob, about some reasonable belief being the trigger or the threshold.
Yeah.
From anything I've been involved in around some of the regulatory issues, I would say pretty damn sure with documentary evidence is more of a realistic threshold in terms of, because otherwise you can look a bit of an idiot if you don't. If you do have just reasonable belief, and that appears to be, possibly optimistic.
Yeah. I mean, in the day-to-day cases I encounter where there's employees litigating or workers litigating about whistleblowing detriment or automatic unfair dismissal claims, often the disclosure they're relying on is a real hodgepodge mix of personal gripe and maybe wider institutional issue a bit thrown in, and a mistaken belief that the employer is legally obliged to do something that it's not, and then you have to argue about whether it's reasonable for anyone to think such a thing. And when you battle these things out in the employment tribunal, each element of the protected interest disclosure definition gets picked apart and
I think
and fought over it.
You're totally agreeing with me. Okay.
Yeah. Thank you, Paul. And Bob, we've got a few more, but let's see what we can get through. I think this one could be potentially a long answer. Let's see if we can give a short one. It's quite a long question, but it's around the reasoning behind not bringing healthcare professionals and transfers of value under the whistleblowing scope, because it doesn't say it here, but presumably because they're just within the ABPI code. So if an employee has a concern on the type of engagement and the principles applied and the question ethical principles that are being set by the company, what can the person do? What should they do? So if they go to the whistleblowing hotline, does that serve as a safe haven for whistleblowing? Now, I'm conscious that you were saying at the beginning that the ABPI code doesn't fall within the list of.
Yeah. I'm sorry, I don't want to butt in, but obviously we have Human Medicines Regulations 2012, which do set down a degree of advertising law. So if it covers the ABPI code and the advertising Human Medicine Regulations, then obviously it would be justified whistleblowing. But if as we all know, the ABPI code goes much further in much more detail than the law. So I think you'd have to distinguish between the two, when it's backed by law or when it's not.
Thank you.
The other point might be that one of the other categories of protected information is a risk to health and safety. And if you're working in the pharmaceutical sector, making medicine,
point,
and there's some wrongdoing within the regulated environment that doesn't involve a breach of a legal obligation per se, but might lead to unsafe medicines going out into the market, then that might bring it within the scope of the regime.
If in doubt, Bob, get legal advice.
Very much. Can I just say one other point? I know you're conscious of time, Paul, but I would say there's a question of whether legally something is a protected disclosure or not, and there's also then the policy issue of what do you want your whistleblowing policy to cover, and it might not be as narrow as everything that's legally protected and nothing that isn't. You might want to encourage a wider degree of employee transparency within your organisation.
And then you'd be bound by that as an employer to follow that if that's what you've set out in the policy.
To a degree, yes. There's a complicated, longer answer to that.
Okay.
But you wouldn't want your whistleblowing policy to have the legal force of a contract of employment. So being bound by it you might not actually be bound by it in the legal sense, but you wouldn't want employees arguing that inferences should be drawn from your failures to follow it.
Okay.
He says as quickly as he can.
Right. Quickly then, right. See if we can answer this one quickly in time for one more possibly. What's the best way to close off a report if the reporter is non-responsive after several follow-ups?
That is a really difficult one, and there isn't an easy way to do it. But I think a series of communications that you've done your chasing the non-responsive person, then you warn them that you're going to issue conclusions, and they've got this deadline to say anything more that they want to say, and then once the deadline's passed, if they're still non-responsive, then come to your conclusions, set out your findings, explain them and communicate them, and then it's done. Easy to say, not easy to do.
Thank you, Bob. And there's a question which I might be able to answer, but let me see if you agree. How would you approach putting in place a single policy that covers UK and Ireland, given it's EU and non-EU? What standard to set? And I'm assuming that because the legislation we've got in this country is UK legislation, wherever it is, you need to get advice from the jurisdiction that you're in.
Yeah, absolutely right. I can't advise on whistleblowing policies in Ireland because I'm not qualified in that jurisdiction, and so you need input from someone who understands the UK regime, and you need to understand what, if any, regulations or laws there are in Ireland about it, and then you feed in both of those to your policy. And you might even have jurisdictional policies if you work. I know that's difficult, but here's what applies in the UK, here's what applies in Ireland. You may need to be telling your employees both of these may apply to you because you work across the two offices, for instance. So